Hi everyone, let's talk about the liability of principals, agents, and independent contractors. In this lesson, we'll describe the duty of loyalty owed by an agent to a principal. We'll describe the tort liability of principals and agents to third parties. We'll describe the liability of agents and principals for intentional torts. We'll describe the principals and agents' liability on third-party contracts, and we'll define what an independent contractor is and describe the liability of those independent contractors. So jumping right in. Principals and agents owe certain duties to each other and are liable to each other for breaching these duties. We've covered this in previous chapters. And agency law is the body of law that establishes the liability of principals, agents, and independent contractors for such conduct. What are these duties? Okay, so first, we'll describe the duty of loyalty. So this is a fiduciary duty owed by an agent not to act adversely to the interest of the principal. So the agent being authorized to act in the interest of the principal shouldn't be acting in a way that would be disloyal to that principal. So there are several common types of these breaches. Self-dealing, usurping an opportunity, competing with the principal, misuse of confidential information, and dual agency. We'll talk about each one of those briefly so you understand them a little bit better. So self-dealing is when an agent profits or tries to profit individually from activities that they do not disclose during an agency relationship. So this happens sometimes when an agent sees some kind of opportunity to personally profit, and they're supposed to be giving this opportunity to the principal, but they don't. And both of these on the page are kind of related to each other. It's spotting some type of opportunity and then taking advantage of it in a way that they shouldn't. So self-dealing, an example might be that if an agent knows that a principal is looking for a piece of land to buy, and the agent actually owns a piece of land, and they point it out, but they don't disclose that they're actually the one that owns it. So they would stand to personally profit off of this. That's self-dealing. Usurping an opportunity, sort of similar, but they spot an opportunity out there somewhere and they decide to take it for themselves rather than passing it along to the principal. So the agent is tasked with going out and finding a piece of land to buy or a business to buy on behalf of a principal, and they find a really good deal, a really good opportunity, and rather than passing that along to the principal, the agent might buy it for themselves. Thus usurping an opportunity that is meant for the principal, and the agent takes it for themselves. Competing with the principal means that an agent who is authorized shouldn't be acting as competition to the principal. So if I'm a salesperson that goes out to sell restaurant equipment for one particular brand, and I go into restaurants and then I start not only offering the brands that my principal has authorized me to do so, but it starts offering some of the competing brands as well. I would be competing with the principal in these deals, and this would be a breach of that duty of loyalty. Another type of breach is the misuse of confidential information. So this happens oftentimes when somebody will take some type of trade secret or like a customer list, a client list, some type of information that is proprietary to that business. And the agent might try to take that list and try to sell it to somebody else or just bring it with them to a different job. This would be another type of that breach of duty of loyalty. Now, the misuse of confidential information is a little bit unique because it exists not only during the agency relationship, but even after. Not in perpetuity maybe, but at least for a certain period of time after they leave. Dual agency happens when an agent would be representing both sides of a transaction. This happens sometimes. I've heard it happening with real estate agents, for example. It's not really a good idea. But if we find out that an agent is representing both the buyer and the seller, they would have to disclose that. If they don't disclose it, they're breaching the duty of loyalty. However, if they disclose it, all the parties involved would have to agree to this dual agency in order for it to be okay. You just have to sign a piece of paper saying, I acknowledge that this person is representing both sides. So if you're representing both sides of a transaction, you're not really fighting too hard for one side or another. So you're probably not going to get the best deal. Not really a great idea. But if two sides are just very friendly with each other and there's no conflicts, then I guess maybe it can work out. Now we shift into conversation about tort liability of principals and agents, and specifically the liability they have to third parties. So now we're talking about scenarios where either a principal or an agent has committed some type of tort. Now, who's liable? Is it going to be the principal? Is it going to be the agent? Is it going to be both of them? Where does that liability lie? And it can shift depending on the circumstances. So principals and agents are each personally liable for their own tortious conduct. So tortious conduct is just conduct that involves a tort. So not trying to confuse you with the terminology there. A principal is liable for tortious conduct of an agent who is acting, and here's the key words, within the scope of their authority. Okay, so a principal isn't liable for all tortious conduct of an agent, but for conduct that's within the scope of their authority, the principal can be held liable for that tortious conduct. So an agent is liable for tortious conduct of a principal only in limited circumstances if we can show that the agent either is directly or indirectly aiding or abetting the conduct of the principal. So the principal is doing some shady stuff, engaging in some fraud or whatever the tortious conduct would be. And if we find out that the agent was aware of it and was in on it, then the agent could also be liable. But if the agent doesn't know anything about it, is not contributing, then the agent usually is not going to be liable for the actions of a principal. The principal is usually liable for the actions of an agent, but it usually doesn't go the other way unless we find out the agent's in on the scheme. So some sources of tort liability, negligence, if a duty is owed to somebody and we breach that duty, intentional torts, so you're thinking about fraud, assaults, kidnappings, things that would be fall under the category of intentional torts that we studied in Business Law 1. And then misrepresentation, oftentimes we call it innocent misrepresentation, but it's like fraud, but you take away the intent element. I'm accidentally making a misrepresentation about something rather than an intentional misrepresentation. So we'll talk about each of those a little bit more, starting off with negligence. So the liability for negligence is based on the theory of respondeat superior, which just is just an old Latin term for let the master respond. It just means that when I employ somebody, then I can be liable for whatever actions they do that are within the scope of their employment. Not for every action they do in their personal life, but when they're acting as my employee or as my agent or both, then I as the employer can be held liable for their actions and the harm that they might cause. So as long as they can show that the agent's an employee and as long as the employee was acting within the scope of their employment, then I as the employer can be held liable for those actions. And this is a type of what we call vicarious liability, being liable for the actions of another person. So the principal is liable for an agent's tortious conduct because of the employment contract. There doesn't have to be a contract involved. It can just be an employment relationship that exists. But anyway, because of this employment relationship between the principal and the agent, so this is key for any business person. You have to understand that you can potentially be on the hook for actions of your employees if they're acting within the scope of their employment. This is why it's very common for if there's like a workplace accident, if somebody's hurt, one of the first things an employer might do is drug test the person involved. And if they can show that the person was under the influence of some drug, you can say they were acting outside the scope of their employment, and then potentially the employer could be let off the hook for that liability. And there are other ways for an employer to try to say that an employee was acting outside the scope of their employment. Sometimes the arguments work, sometimes they don't. But this is pretty important to understand for any person engaging in business. So we understand that principals can be liable for the actions of employees and agents when they're acting within the scope of employment. And then we also understand that a principal would not be liable if the employee is acting outside the scope of employment. But there are often some situations that kind of blur the lines. So we have a few things here to talk about, just questions that come up commonly. The first one we talk about is frolic and detour. So if I'm working for somebody, if I'm an authorized agent of them, and let's see, they send me on assignment to go drive across town to do something, sign a piece of paperwork or close some kind of deal or whatever. But along the way, I decide that rather than going directly there, what I'm going to do is veer off, and I'm going to go look at some real estate that I had been considering whether to buy. So I'm kind of doing my own thing. I'm on my own little side mission while I'm on the way to what the employer actually wanted me to do. So this could be considered what they call frolic and detour. So the agent, I'm doing something during the course of employment, but I'm doing something that would further my own interests rather than the principal. The principal doesn't care if I buy this house or whatever. It's not what they hired me for. I'm just doing something for myself while also acting during my employment. So that usually is going to let the principal off the hook if they can convince the court that this was a frolic and detour. The coming and going rule is understood by most people, but it's a question of what about, so if I employ somebody and I task them with driving from one place to another or flying from one place to another, then I can be liable for things that happen while they're traveling. But that doesn't mean that I'm liable for the commute to and from work. Okay, so when an agent or an employee wakes up on their way to work, I as the principal am not liable for that. And after they leave work and they're driving home, I'm not liable for that. That's the coming and going rule, or the going and coming rule, whichever way you want to say it. So, generally that falls outside of the scope of what a principal would be liable for. Finally, on this slide, we have the dual purpose mission. So this is when a principal requests an employee or agent do something, run some errand, do some act, they're doing something. And at the same time, the agent is doing some of their own personal business. So it might be the principal object here was the agent was out doing their own thing, and then the employer just calls and says, hey, while you're out doing that, can you do this thing for me? And then we have to analyze the circumstances to find out, okay, is this primarily personal business of the agent? Is this primarily the business that the principal asked them to do? If you can show that it's definitely one or the other, then you might be able to assign liability that way. But if you can't, then a lot of places just sign joint and several liability for both the agent and the principal. So what we're talking about during these things is often something as simple as a car accident that happens while somebody's out traveling for work. Where I work at the school, every year we have to sign a travel authorization form that says the school authorizes me, Jeremy Railton, to travel for business of the school. So if I'm going to another campus to teach a class, or I'm going out to check on a student that's working at a business in the community or something like that, if I get into an accident and somebody gets hurt, that person is going to sue. And even if I'm personally hurt, But let's say there's a third party involved and they sue me for causing them injury. And I can say, well, actually, I was just acting as an agent for the college. So your real business is suing the college. This is what we're talking about with all these things here is when somebody suffers an injury, especially a third party, who's going to be liable? So if you remember in Business Law 1, we talked about intentional torts as well as unintentional torts. But the intentional ones are, you're talking about assault, battery, false imprisonment, other intentional conduct that causes injury, whether physical or financial, to another person. So a principal is not liable for intentional torts of agents and employees that are committed outside the principal's scope of business. So we're saying these key words a lot. So, within the scope of employment, within the scope of a principal's business, things like that. So the basic idea is that if I'm acting as part of my job, and a tort is committed, then the principal can be held liable. But if I'm acting outside of the scope of my employment, then the principal's probably not going to be held liable. So sometimes you see weird videos on the internet where, a cashier gets into some type of argument with a customer and it devolves into actual physical violence. And then we have these questions of, okay, if the customer got hurt and they sue for assault, who should they be suing? Is it just the cashier personally, who probably isn't going to have all that much money, or can they sue the business as well? And then we would have to get into an argument in front of the court about whether or not that cashier was acting within the scope of their employment at the time that the assault happened. So, we see these kind of things happen quite often. So courts have come up with a couple different tests to determine whether the acts or the torts were committed within the scope of employment. One is the motivation test, which is not in use as much anymore, but they would use this test saying that, well, what was the agent's motivation in committing the tort? Is their motivation that they were trying to promote the principal's business when the act happened? And if so, they can say it happened within the scope of employment. The problem with this is it's pretty difficult to assess what a person's motivation is, to get inside of a person's head and figure out, well, what was their intent? So a lot of places have moved on to using the work-related test, and this is what I've seen in most cases that I've seen involving North Carolina. It looks like they're using the work-related test. They don't name it specifically, but it looks like this is the way they analyze cases. And now we're just looking at, all right, when the act happened, okay, was the agent within work-related time or space? Is what they're doing work-related? Are they on the premises of the employer? Are they on the clock right now? It's a little bit easier to decipher those things rather than getting inside of a person's head and trying to judge their motivation. So that's why a lot of courts prefer that test over the motivation test. Now, this was a case that happened in the state of New York, so we can't necessarily assume that the same thing would happen here in North Carolina, but I think it's good to illustrate at least the principle of how the motivation test works. But basically, you have a cashier who's just kind of bored and is ready to leave for the day. And a customer comes up and the cashier is kind of joking around with him about how, can they, make it fast because I'm trying to get out of here kind of conversation. And as part of that, the cashier bags up a box of shoes and some shampoo and tosses it at the customer, who doesn't see it coming, and the bag just hits him in the face. So then the customer sues. So then the court gets into this conversation about, well, when the cashier threw that bag, was their motivation to further the business of Walmart, or was it their own personal motivation that they were trying to get things over and done with to get out there as fast as they can? And the court said that the personal motivation of the cashier was what was going on, so they relieved Walmart of liability in this case. Now, that is one case that happened in New York in 2010. So, if the same thing happened in North Carolina, maybe things would go differently. I don't know. We'd have to see what happened. But that's an application of the motivation test. as opposed to the work-related test. If we apply the work-related test, then it probably would have gone differently. They probably would have found that the person was on the clock at their station as a cashier, and that's enough to be work-related to where Walmart would have liability. Now we look at misrepresentation. We take misrepresentation and break it down into two categories, but basically both involve a false statement that is made. Something untrue is stated about a piece of property or a business deal or whatever. A principal is going to be liable if an agent makes a misrepresentation, as long as they're acting within the scope of their employment. There we go again with the key words, within the scope of their employment. Intentional misrepresentations are often just called fraud. It's usually called fraudulent misrepresentation, all wraps up into the same thing. But the idea here is that the agent makes a statement that they know is not true in order to induce the other party to enter into some type of transaction. An innocent misrepresentation is a little bit differently. They either just didn't know that what they're saying was false, or maybe they should have, but they were just negligent and not investigating whether what they were saying was true. But either way, in both cases, a principal can be liable for these misrepresentations made by the agent within the scope of their employment. Now we shift just a little bit to talk about contract liability instead of tort liability. The basic idea is that agency law imposes contract liability on principals and agents. The normal thing to happen is that a principal who authorizes an agent to enter into contracts with third parties is liable on those contracts. So I, as the principal, don't have time or just would rather not deal with this particular contract, so I authorize an agent to go out and sign it for me. So then the principal is going to be held liable for that contract. They're bound to it just as if they themselves had personally signed for it. An agent is usually not going to be held liable for a contract that they sign on behalf of a principal, but under certain circumstances, they can be. So we'll talk about that just a little bit here. It depends on disclosure, the amount of disclosure. So first, we talk about a fully disclosed agency relationship. This is where the third party knows that the agent is acting on behalf of a principal, and we actually identify who the principal is. So it'd be common at the end for the agent to sign, "Here I am, Joseph Smith, agent for," and then naming whoever the principal is. So as long as we're fully disclosing it, now the agent is not going to be liable on that contract if there's a breach or a problem or misrepresentation or whatever. The principal would be the one who's liable. Then we move into a little bit fuzzier situations. So now we have a partially disclosed agency. This is when the third party to the contract knows that there is an agency relationship, but doesn't know who the principal is. So this could arise in a couple different ways. One is that we can be intentionally concealing the principal, or we could have just accidentally left off the principal's name when the agent signs. They could say Joseph Smith, agent, and then forget to name whoever the principal is. Now, sometimes people intentionally conceal who they are because they're afraid it might influence the deal in some way. So this often happens if a wealthy person or a very well-known person is trying to buy a piece of property or a business or something like that. If the third party knows that it's Warren Buffett who's trying to buy this business, then maybe they'll try to charge a lot more than they would if it's just, Joe Schmo down the road trying to buy their business. So Warren Buffett would rather just keep his name off of it entirely if he can to try to get a better deal. So that's kind of the kind of reasons that somebody might try to conceal the principal's name. So if the name of the principal is left off, both the principal and the agent can be held liable if the principal fails to perform on the contract. And that's because, when the third party's signing, they have no choice but just to rely on the good name and reputation of the agent, since we don't know who the principal is. So that's why we would hold them liable in that situation. Finally, we have an undisclosed agency. This is when the third party doesn't even know that an agency relationship exists at all. So as far as the third party knows, it could be the agent themselves who is buying that business or agreeing to the contract, and they don't know that they're actually acting on behalf of some other, third party principal. In this situation, both the principal and the agent are liable to the third party if the principal fails to perform the contract. So, every now and then you hear about stories like this where this takes it a step farther than the partially disclosed agency. But you hear stories about, when Walt Disney was trying to buy land in Florida on which he would build Disney World, but he didn't want people to know that it was him that was buying the land. They really didn't want anybody to know that even that there was an agency involved. They just set up some fake companies and started buying it in the name of these other companies. So he could get a better deal on the land because he was afraid that, if they knew that it was Walt Disney, then of course they would try to charge him more money. So there are reasons for these type of things to happen. It's a little bit less common than just a fully disclosed agency. So we've talked about, scope of authority a lot. If an agent is acting within the scope of their authority or within the scope of their employment or, whichever way you want to say it. But what about when an agent exceeds the scope of their authority? We talk about the implied warranty of authority. That means when a third party is interacting with an agent, the implication is that the agent has authority to act in the way that they're doing and to sign the contracts that they're signing or do the deals that they're doing. So that's just implied. So then later, if we find out the agent actually didn't have authority. So if I sign with a real estate agent and I say, go find me a house, the house has to be $500,000 or less. It has to have 3 bedrooms, at least 2 bathrooms, has to have at least 2,000 square feet. And I give them these specs. And they go out and they start looking at houses and they find a great house that meets most of the specs that I set out for them, except for the house cost $1 million. And they sign a contract to buy this house. Well, I can't afford $1 million. So they were acting outside the scope of their authority. So I, as the principal, am not going to be liable on that contract unless I later choose to ratify it. Unless, if I find some money somewhere and I say, you know what, it is a really nice house, so actually I'm going to honor this contract, then I, as the principal, can ratify it. But, if the principal doesn't ratify it, then they're not going to be held liable. What the third party would have to do to get restitution there is they would have to show that they relied on the agent's misrepresentation of their authority, and that they were unaware that the agent lacked this status. If the third party was aware that the agent was acting outside the scope of their authority, then they might not have a claim, and we might just have a valid contract here. Or, you wouldn't actually have a valid contract. You just, as the third party, they wouldn't be able to recover any damages. Anyways, that's a better way to say it. Now we shift discussions a little bit to independent contractors. You probably have talked about the employee versus independent contractor relationship in another one of your business classes, but we'll rehash it here just in case. But an independent contractor is a person who contracts with another person or business to do something for them who is not controlled by the other, nor is subject to the other's right to control with respect to his physical conduct and the performance of the undertaking. That's a very wordy way of saying that I'm hiring somebody else, but they're not my employee. They have their own business, and I'm just asking them to do this one thing for me. Then they would be an independent contractor. So if I hire a plumber to come to my house and fix, a plumbing issue that I have, I'm not employing them as an employee. They're their own independent business. They have their own thing that they're doing out there, and they're not coming to work for me permanently. They're just going to do one job and then they're going to leave. That's an easy, clear-cut example of an independent contractor. So generally speaking, a principal is not liable for the torts of independent contractors that they hire. And when you talk about businesses and classifying people as employees versus independent contractors, there's a lot of reasons why a business would try to classify workers as independent contractors as opposed to employees. And it usually involves things like responsibility for paying payroll taxes and workers' comp. And this liability here is another big reason why. When trying to determine whether somebody is an independent contractor or an employee, we look at several things. They all involve the right to control the way that the work is done. That's usually, what we're talking about. But so we can look at whether the worker is engaged in a distinct occupation or whether they are an independently established business. We can look at the length of time the agent has been employed by the principal. We can look at the amount of time that the agent works for the principal. We can look at whether the principal supplies the tools and equipment versus the worker bringing their own tools and equipment, which would seem to suggest that they're an independent contractor. We can look at the method of payment, whether it's by an amount of time, which would sort of lean toward employee, or by the job, which would lean toward independent contractor. We can look at the degree of skill necessary to complete the task. The higher the skill level, kind of suggests independent contractor, but it could kind of go both ways depending on the circumstances. We look at whether the worker hires employees, of their own to assist him or her. That would suggest that the person has their own business and that they are an independent contractor. And whether the employer has the right to control the manner and means of accomplishing the desired result. So, do you have to show up at a particular time? Do you have to wear a particular uniform? Do you have to do it a particular way versus just getting the job done with some parameters for satisfaction? Are the ways that we could go in and try to analyze whether the person's employee versus independent contractor. So, bringing it back to the point of this chapter, like we said earlier, the principal is not liable generally for the torts of its independent contractors. The contractors are personally liable for their own torts that might have been committed. However, that said, principals cannot avoid liability for inherently dangerous activities that they assign to independent contractors. And this gets wrapped up into a legal concept of strict liability. But now we're talking about handling explosives, clearing land by burning with fire, handling, keeping dangerous animals like lions and bears and things like that. Usually we apply strict liability there, and the principal could be held liable as well as the independent contractor. But, that's a minority of situations, and you would have special contracts for those to try to figure out who's liable for what. But that's the general rule there. Now, a principal can authorize independent contractors to enter into contracts on behalf of the principal, and then the principal would then be bound by those contracts. So sometimes businesses hire like a consulting firm or something like that to come in and help them out. The consultant would be an independent contractor. However, if the principal decides to do so, they could authorize that contractor then to then go enter into contracts on behalf of the principal. So as long as they're acting within the scope of what they're authorized to do, of course, then the principal would be bound to them. However, if an independent contractor goes outside of what they're authorized to do, so if we're acting without the principal's express or implied authority to enter into contracts, then the principal would not be held liable, and then the independent contractor would be held liable for that contract. So this case involves a car dealership, and it is in the state of Oklahoma. So we have to understand a few things from the get-go. One is that in Oklahoma, and the way that Ford does their contracts, they give licenses out to people who establish dealerships, and they specify in the contract for the license that the dealership will be acting as an independent contractor and is not an employee or necessarily an agent of Ford. They're their own thing. So what happened was we have a dealership that's established, and they get involved in some shady dealings. They're just not paying the bills that they were supposed to be doing. They're shorting some customers on down payments and stuff like that. So the dealership closes, and people who have been injured financially are going to sue. So then the question arises, they sue both the dealership and Ford. And the lower court, Ford tries to say, well, they were an independent contractor. I can't be held liable for their actions. The lower court disagrees and holds Ford liable. So then they appeal to the Court of Civil Appeals in Oklahoma to analyze whether or not Ford was actually can be held liable here as a principal. So the question of, is Ibex an actual, Ibex was the name of the dealership, are they an actual or apparent agent of defendant, who is Ford, or are they just an independent contractor? And the court finally decided that Ford, or Ibex rather, was an independent contractor, and thus Ford cannot be held liable for the actions of Ibex, because Ford wasn't controlling how they ran the dealership and how they were making payments and how they were selling the cars. They just provided cars in a financial relationship to the dealership sold them, and then they paid Ford. So that was the extent of the relationship, and they couldn't be held liable in that situation. So that wraps up this chapter. If you have questions about stuff, always feel free to reach out to me. Otherwise, I hope you have a great day.